being here at short notice, and thank you for, and this I say to the media, for being here to demonstrate your commitment to keeping the citizens of this country factually well informed. I thought it necessary to call today's press conference to publicly address two matters which have been occupying the attention of those consuming news media content over the last week. Firstly, the matter of the United Nations Office on Drugs and Crime draft firearms bill, and I emphasize that, the United Nations Office of Drugs and Crime draft firearms bill, for which a comprehensive media statement was released by my office yesterday. And secondly, the matter between the Auditor General and the Minister of Finance, to which the Attorney General's office, by extension, has become a related party in another matter. And ladies and gentlemen, forgive me, but I've been having some difficulty with my voice, so you will find that I will probably not spend quite as much time as I would like to spend with you today, because I'm speaking against my doctor's orders today. The first matter I wish to reiterate a point on that was made in my release yesterday. 2 points. One, the document that was made public is not in any way to be considered or misrepresented as government policy. And two, the correspondence which has been leaked to the media represents early formative discussions with the United Nations Office on Drugs and Crime and internal government agencies which my office considered it necessary to consult. That document, which is a proposed draft firearms bill 2024 for Trinidad and Tobago, was developed by the United Nations Office on Drugs and Crime for my consideration as Attorney General. That draft UNODC, the acronym for United Nations Office on Drugs and Crime, that draft UNODC bill is aligned with the international legal framework on firearms and makes proposals for a comprehensive system of firearms control regulation proposed to me by the United Nations Office on Drugs and Crime for my consideration in formulating, in early formative stages, such proposals as I may bring to the Cabinet in due course. This draft bill was circulated by my office to stakeholders in March 2024 for the sole purpose of receiving feedback during a comprehensive formative consultative process. It is a discussion draft amongst the UNODC and government agencies, no more, so that any attempts to misrepresent the contents of that draft as government policy or as anything else other than a draft for discussion at this point can only be categorized as mischievous misinformation, or in simpler terms, a lie. The bill is itself still undergoing active formative consultation, after which it will be reviewed by my office and referred to the Law Reform Commission for consideration and policy consideration and development by the Cabinet for the Cabinet's approval. It has not yet reached the stage of being finally presented by my office to the Law Reform Commission. So there is still some significant way to go before it makes its way to Cabinet and thereafter to Parliament for debate. It is unfortunate and a real cause of concern for me as Attorney General that some trusted office holder would release this document into the public at such a sensitive formative stage in the consultative process. Such action is to be deplored and can only be regarded, in my view, as dishonest political mischief. I trust that the reasonable-minded citizens will understand that the remit of the Office of Attorney General, which I am honored to hold, includes reviewing the laws of the Trinidad and Tobago with a view to their systemic development and reform as that may become necessary, and that preliminary steps in this process before a document is submitted to Cabinet for approval cannot represent government policy. This document has not been submitted to Cabinet, does not represent the policy of the government of the Republic of Trinidad and Tobago, and has served only to give the UNC opposition an opportunity to make wild statements not grounded in fact. I regret in today's print media to have read one of the columns, and I will emphasize first of all the letter which was leaked to the media. One of the most important lines in this letter, which was read to the media, is on the second page, which says it is anticipated that this model law will eventually repeal and replace the act subject to the approval of the Cabinet. That was stated in black and white in this letter, which was leaked to the media. That letter is heralded today in very bold headline in terms. The passage which I've just read that says subject to Cabinet approval is quoted in that article, and yet the headline of that article says government looks to create gun-free zones. In the fifth column of that article, my caution that this is subject to Cabinet approval is quoted, and yet the headline represents the contents of my letter as a government policy to create gun-free zones. That is not responsible journalism. I turn, ladies and gentlemen, to direct attention to the matter of the Auditor General and the Ministry of Finance in very limited terms. And I stress in limited terms for the reason that I will refer to. The Minister of Finance held a press conference yesterday. He has spoken to the measures that have been taken by the Ministry of Finance and approved by the Cabinet by way of an independent investigation, and that will be the remit of the Minister of Finance. I'm not going to speak to that. The public will now, in fact, be aware that a lawsuit has been filed against the Office of the Attorney General, and so it is prudent that I limit my comments on this issue. Nevertheless, and again to encourage responsible, factual reporting by the media, it is important that I address some misinformation that has been placed in the public domain and allowed to masquerade as the truth. One such false assertion is the suggestion that I have refused to pay for the legal fees of an attorney retained by the Auditor General over the provision of her audit report. That is simply not true. I am compelled to repeat the facts of two items of correspondence which have been reported on, but insufficiently in the media, to correct the deliberate misrepresentation on this issue, specifically as it relates to that correspondence between my office and that of the Auditor General. On the 17th of April 2024, I received a written request from the Auditor General for a legal opinion on sections 24 and 25 of the Exchequer and Audit Act, Chapter 69, Number 1. Very specifically, I was asked to provide a legal opinion on sections 24 and 25 of the Exchequer and Audit Act by the Auditor General. I took legal advice. 2 days later, on the 19th of April, I responded to the Auditor General, and I'm going to quote the entirety of my letter so that it can be accurately reported. Quote, I acknowledge receipt of your letter dated the 17th of April 2024 with attachments requesting my advice on whether the Auditor General is required to consider the amended statements referred to in your said letter in light of the provisions of sections 24 and 25 of the Exchequer and Audit Act. Consistent with my duty under the Constitution, and as you are aware, I am already advising the Honorable Minister of Finance on this very matter. I refer to the pre-action protocol letter dated the 16th April 2024, which is one of the attachments to your said letter to me. In the circumstances, it would be inappropriate for me to render any advice to you on this matter. I recommend that with all appropriate urgency, you should retain independent counsel to give you such advice. I give the undertaking that as Attorney General, I am prepared to pay reasonable fees incurred by you as Auditor General for the retention and obtaining of that independent advice. I repeat that part of my letter to the Auditor General, dated the 19th of April. I recommend that with all appropriate urgency, you should retain independent counsel to give you such advice. I give the undertaking that as Attorney General, I am prepared to pay reasonable fees incurred by you as Auditor General for the retention and obtaining of that independent advice. Sincerely yours, end of quote. Subsequent to the Auditor General sending her report to the Parliament on the 24th of April, 5 days after my letter to her of the 19th, I received correspondence from Anand Ramlogan's chambers on behalf of the Auditor General and answered the following correspondence in my letter, in the letter of the Chamber's Director of the of the 19th. Sorry, I've got to get the date for that. But I replied to the Auditor General's letter, and this is what was said in the letter written on my behalf by the Chamber's Director. I write on behalf of the Honorable Attorney General. Your letter dated 28th April 2024 to the Honorable Minister of Finance has been drawn to the attention of the Honorable Attorney General. In that letter, you have stated that by letter dated 19th April 2024, the Honorable Attorney General recommended that the Auditor General seek her own counsel. Please be advised that by letter dated 17th April 2024, the Auditor General sought the advice of the Attorney General on whether she is, and it was quoted, required to consider the amended statements in light of the provisions of sections 24 and 25 of the Exchequer and Audit Act, unquote. In response to that request, the Attorney General recommended to the Auditor General that she, quote, should retain independent counsel to give such advice, unquote. The letter continued. He also stated that he was prepared to pay reasonable fees incurred by the Auditor General for the retention and obtaining of that independent advice. It is clear that the recommendation and undertaking of the Attorney General was specific and related and confined solely to the advice sought by the Auditor General in her letter to him on the 17th April 2024 and not in respect of any other advice or matter. Please be guided accordingly, unquote. I was expressly clear throughout regarding my willingness to pay the reasonable legal costs as it relates to the retention of counsel for the advice sought by the Auditor General. The reports that there was a refusal on my part to do so is erroneous, or worse, is intended deliberately to mislead. I will spare you any further details of the exchanges, as it has become evident over the last couple of weeks that all of the correspondence issued by the attorneys representing the Auditor General have all been sent to and are all well known to you, members of the media. It was essential, however, that I set the public record straight as it reports to this factually incorrect reporting of the letters which I have written to the Auditor General and to her attorneys. I'm open now to a limited number of questions on the two issues which I have addressed, as I have other obligations to attend to shortly, and my voice might not hold out for the entirety of all of your questions. Thank you very much.
AG Sonolala, TDT News, you said you were willing to pay legal costs and so on. Have you received any bill or statement from the Auditor General of how much this is costing so far?
No, I have not.
Touching on that topic as well, is there a budget that you are ceiling? Because you emphasize reasonable fees. Is there a ceiling that you have already established that you won't go beyond?
No, it would be premature for me to establish a ceiling. One would have to look at the work that if a bill were to be sent to me, one would have to look at the work that is done. There is a process, for instance, in the High Court that is normally attended to by registrars of the High Court. It's called taxing the cost. You look at the work that is done, you look at the time output, and you assess what is reasonable against the work done, time output, complexity of matters. So it would be entirely premature of me to place a ceiling before a bill is submitted to me.
Are you open to one or two questions outside of what you touched on? Just one or two?
Well, I'll do my best, but I have to say that I'm, not inclined, and I think you know that very well, Mr. Levan. I'm not inclined to shoot from the hip.
Yes,
So,
I'm fully aware. But before I do that, I will allow my colleague, if he has any questions on the two matters you raised. Thank you for giving way, sir. Apart from the issue with the Auditor General and that's happening now, there's another issue brewing between the DPP and the judiciary with regards to the Dina Sitahal matter. Is the DPP yesterday issued a release saying that he has not received the actual physical copies of the case file, and therefore he can't file the indictment. Is there any consideration at this time, given what he said, to make amendments to the legislation so that he can file an indictment with copies, or if not certified copies?
I'm not going to comment on anything said by the DPP. Sorry.
Fair enough. Sticking again with the DPP. Last year around this time, there was another issue that came up between yourself, the DPP. One of the promises made, well, I wouldn't say promise, one of the suggestions made last year to solve the issue was the importation of attorneys of a certain ilk from within the Commonwealth. Where are we on that process?
That was rejected by the DPP.
And when was this rejection? Because I can't recall that.
Last year.
Okay.
Hi, good afternoon. Mr. Moore, Gregory McBurney from Newsday. I know you said you're not going to comment on what the DPP said, but has the government sought any legal advice, or if not, what is in your legal luminary experience in terms of what the DPP's request for a hard copy of documents? Do you think that is something that is necessary for a case to move forward?
No comment on what has been said by the DPP.
All right.
Outside of what the DPP said, I'm not going to stress on what the DPP said. As far as you are aware, and as far as the law dictates, can an indictment be filed without the physical copies?
I'm not getting into that, Mr. Levin. Sorry, that is an issue that is under discussion between the DPP and the Chief Justice. I'm not getting involved in that. No comment.
My final question. We are nearing the end of the Police Commissioner's first extension. The Cabinet would have to make a decision on whether or not she gets a further extension. Has that consideration been done, and if so, what is the decision?
It would be premature for me to speak to something that Cabinet has to consider. I would not wish to be premature.
So the Cabinet has not met and discussed this particular issue?
I'm not at liberty to discuss what Cabinet has met and discussed. Until a decision is made, a minute is produced, and that then becomes available for government as government policy.
The reason why I'm asking is because we're pressed for time, and I know the Prime Minister is out of the country for some days. Well, the Commissioner of Police time expires on, if I'm not mistaken, the 14th of May, which is next week, Tuesday. Being that the Prime Minister is out of the country, again, any discussions on this?
Well, I would say that you are correct as to the expiry of the Commissioner's current term, and I would say, secondly, that we have an acting Prime Minister who, on record, has demonstrated himself to be a very capable acting Prime Minister.
Mr. Moore, can you just guide us on what is the process, though? Is it that, I mean, you all said you haven't discussed it, but does she have to have an appraisal before you all discuss it, just for the general public, not exactly what will happen in her case, but what will the process entail this in this circumstance, given the Court of Appeal ruling that you all would have won this morning?
Well, I mean, and regrettably, the Court of Appeal ruling this morning hasn't yet been written, and therefore I'm not at liberty to speak in any detail to the ruling, other than to say, and I am gratified by this, that the recommendation of the Cabinet, which had extended the term of office of the Commissioner in its current passage, has now been supported by 4 judges of our Supreme Court, Justice Rahim in the court below, and now Justices Musai and 2 other judges who were in the Court of Appeal today, so that the Supreme Court of Judicature agrees with the exercise of the discretion which the Cabinet exercised with respect to the extension of term. That is an interpretation of the Constitution and the Police Service Act, Section 75, and it was lawfully done, and no doubt consideration would be had to those sections again, as and when Cabinet decides to consider whether anything is to be done further. But as I say, I don't want to prematurely pre-guess what Cabinet may or may not be inclined to do.
Also, as the legal advisor to the Cabinet, I know that the Police Commissioner, we haven't seen her take any leave. Is it that the government would have bought out her leave because there hasn't been an acting commissioner, which would have had to be debated in Parliament, and that wasn't done? And since she's up on the 14th, what is the situation with the Police Commissioner's leave, and what have you advised the Cabinet, if at all?
I haven't apprised myself of the position of the Commissioner's leave, so I'm not at liberty to speak to that without having looked at the records of what may or may not have been done.
Okay. Also, we've seen the post advertised in the newspaper. Where does that leave the post of the Police Commissioner, the incumbent Police Commissioner? Has the government factored in any legal action? Because if the post has been advertised, and there is an incumbent, where does it leave the incumbent? And also, is it that it's giving false hope to applicants? So has that post been advertised? Has the government factored that in at all? Any possible legal action as a result of that?
Forgive me, sir, what's your name?
Gregory McBurney from Trinidad.
Mr. McBurney, you've rolled up a lot of questions in that last barrage. But 2 things that came out of the questions that you asked and the premises on which you pitched your questions is that you refer to advertisements. Those are advertisements by the Police Service Commission. I don't purport to speak on behalf of the Police Service Commission, and I suggest that all of your questions should properly be directed to the Police Service Commission.
Just going back to the initial one, I know you said the government will be guided by the Section 75 and I think it's 123 in the Constitution. But just for the general public who may not be necessarily accurate with the laws of Trinidad and Tobago and the Constitution, can you just explain to them what the process is now, given that that 1-year extension is about to be up?
The process is that the provisions of the legislation will have to be looked at, and the Constitution will have to be looked at. A recommendation may or may not be made to the President. I couldn't say what that recommendation will be, and if a recommendation is made to the President in her discretion will act on that discretion.
And is there a timeline you could give the public that they could expect? Because all of this has to be done. It still has to be debated in Parliament as well. And we're looking at what, in a week, less than a week? Do you think that, if you can't give a timeline, do you think that that timeline will be met by the 14th?
Well, the timeline that I can agree with you on, Mr. Maguire, is that the 14th of May is the last date on the current extension that has just been affirmed by the Court of Appeal. Beyond that, I don't want to speculate on what may or may not be done.
Just one question going back to...
I'm going to ask you to wrap up shortly, Mr. Levin. My
Yeah.
voice is giving out on me.
I recognize, and I hope you recover and swiftly from whatever is ailing you. Going back to the one of the first 2 points that you raised, oh goodness, you made me forget my question, sir.
Sorry, there was one other question I forgot to ask. I know a position such as the police commissioner, I'm assuming that as the advisor to the cabinet, you'll have to have some sort of sight of the contract that is to be given to the police commissioner. Part of that contract, I'll assume, will be based on an appraisal. Are you able to say if an appraisal was done, and have you had sight of it as the legal advisor to the cabinet?
I'm not prepared to engage in that conversation at this time. Ladies and gentlemen, thank you all very much for attending at short notice. Good afternoon.
Transportation in Kenya. It's like nowhere else on Earth. With buses and smaller vehicles called matatus.